And Nels,
Feel free to
totally surrounded by those
out there where that came from.
They decided
She's
that
going to be available afterwards as well. A special thanks and welcome to our panelists here this afternoon. We're very appreciative of you taking the time to come out on a Saturday morning. And we're honored to have such a distinguished group. In the middle is Jennifer Dean, who we welcome back. She left last spring and is now working for I'm going to say that wrong. Poarch.
Close. Poarch. Like a front porch.
Poarch. Made it too hard. Poarch law firm in Roanoke, where she does immigration law. And Jennifer was very active in a number of competitions, moot court negotiations. And I can personally attest that she is a fearsome negotiator and advocate, because she got me one heck of a shop, this Morgan buyer, last January. So, welcome, Jennifer.
Thank you.
On the far side is Professor Chris Russell. He is an adjunct professor at WNL and has been since 2007. He teaches the public prosecutor's externship class, but he has been a prosecutor since 1998, initially for Lexington, and since 2004 for the city of Buena Vista as the Commonwealth's attorney. So, thank you, Chris. And finally, on this end we have Judge Rudolph Bumgardner III, and he is coming to us. Well, he's born and raised in Stanton, he tells me, and he he graduated from WNL, let me start there, in 1966. He went in the Army for a couple of years. He was in private practice and a prosecutor for a couple of years apiece. And in 1978, he won election as a circuit judge, the 25th Circuit, I believe, and has been a judge ever since. He was appointed to the Virginia Court of Appeals in 1997, and he took senior status in 2005. So thank you very much for being here, Judge. And that's just, aside from that brief intro, I'd like to start by having each of the panelists in turn fill in any holes they'd like, and give us a sense of your experience and interest in legal research and what you've done. If we could start in that same order, Jennifer and Chris, and then the Judge.
Well, thank you. As you know, I work for an immigration law firm in Salem, Virginia, and a lot of our practice focuses on very time-specific deadlines. We'll have a client come to us and let us know that their husband, their brother, their sister was picked up by immigration authorities and that they're put in deportation proceedings. So what that starts is an immediate litigation type process in the court system where we have to file motions, we have to submit evidence, and get them a hearing before the immigration court before they're deported in the next week or two. So our legal research in our office mainly focuses within these very narrow time constraints. So what's most important that the attorneys and support staff in our office have discovered is being as efficient as possible, especially when we're working with a cross-section of federal statutes, federal and state, local case law, and also working with the other aspect of the immigration system, which is an administrative system. So we have an agency, government agency that processes applications for relief, and the court system that rules on that relief. So for us, it's important to work with each other and work off existing knowledge we have in the law firm, and also save this research so that we have it for easy access for future cases, and knowing what sources to go to at a moment's notice to get a quick answer that you're looking for when you're faced with a pressing deadline.
Well, thank you all for being here, and to law school for having me. I've been the Commonwealth's attorney in Buena Vista since 2004, and at that time, the late Professor Roger Groot, who's famous around here, and was a Buena Vista resident for many years until he passed away, was such a great asset to all of us in the local bar in this area. And he used to, I was thinking about the tools I used for that I use and did when I first started. And the Buena Vista Commonwealth Attorney is a one-attorney office, so we are one of the smaller first-class cities in the Commonwealth. I can't think of a smaller one that has its own court system. Bumgardner might be able to correct me. Clifton Forge, when I first moved to this area, used to have its own court system and became a town and merged with Allegheny County, which is in our judicial circuit also. But anyway, I'm by myself there, and I was lucky to have Professor Groot would come to my office every time there was a new edition of his, I guess it's sort of what you call a horn book, but a book on substantive criminal law in Virginia, and he would present the office with a complimentary copy of his book and an updated one every time there was a new edition. And I always start there. Now Professor Ron Bassigal at the University of Richmond took over where Professor Groot left off, and I have a subscription to his book, which comes once a year. So I start there a lot, and I use Lexis to do a lot of my research. One thing I can't really speak well to is cost-efficient research, because in the government office, there's both good and bad. I've had an unlimited plan, but I think in part, I'm able to get that because I don't need access to every jurisdiction in the country. So I just have Virginia Court of Appeals, Virginia Supreme Court, the Virginia statutes and rules of court, Fourth Circuit case law, U.S. Supreme Court case law, and a few treatises online that come along with that package that I don't use too often. But in my job, where unlike a lot of practicing lawyers, I try a lot of cases. Many of them are short, half-day trials or a fourth of a day trial, one witness, but that doesn't mean they're not complicated. Trying a DUI can involve some complicated issues under the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, some complicated science, lots of statutory law that you need to know, and so I do research in small chunks for lots of different cases, and in a practice like mine, our circuit court, which is our main trial court, we only have one day of circuit court every couple of weeks, and there might be 10 cases on the docket to be tried that day. I was thinking about legal research and thought of an interesting story to share with you, to tell you what it's like in a small practice where you do a lot of cases in a small town. I had a case that involved, this was a month or two ago, the defendant was charged with manufacture of a firebomb. And he was, part of the story was he was threatening to harm himself and had some explosives and guns in his house, and the police went out to try to deal with the situation, and there was a family member inside they were trying to protect, and there were a lot of issues in the case. One was the police entry in the house under the Fourth Amendment that had to be looked at. But one that came up in the middle of the trial was a witness for the defendant was a clinical psychologist and claimed a privilege as to some questions I was asking him on cross-examination. He said, I don't think I should have to answer that question. And I said to the judge, I believe the law was on my side on this point, and the judge said, well, let's take a recess. We have the lawyers come back to chambers. We went back, and the judge said, I have a decent idea on the answer to this question, whether I can compel the witness to answer that question, but I'm not sure. And I think it's the lawyer's job to find the answer to that question. And the defense lawyer who objected and wanted his witness to not have to answer the question said, well, he's a Lexington practitioner. And he said, well, I don't have any ability to find the answer to that question right now. And the judge looked at me and said, well, your office is right next door. Why don't you go find the answer? We'll take a 10-minute break. So I had 10 minutes to go quickly find the answer to one specific question. And ran across the street and grabbed another book that I use all the time, Friend on Evidence, which is a hardbound volume that's supplemented every year. Looked at the table of contents in the index and found a specific section that was about 2 pages long and read that, and found a case that supported the point I was looking for, and then jumped on the computer and typed in just the citation in the box on Lexis, and it came up, and then looked at the Shepherds and made sure it was still good law, and ran back and was able to answer the question in about, he let me have about 20 minutes to do all that. But that's what it's like doing research in the real world, especially in small trial practice.
It's a pleasure to be back here, too. I might add just a couple of things about my background that I have been around this place since I finished. I had a class here for 20 years, and both my kids have gone here. So I've been through what you all have been through, not only personally, but from the slightly detached view. In fact, one time, Ann was studying for the bar exam, and she calls me up on a Saturday night about 11:30 with some procedure question. Everybody knows how you love procedure. And she asked me, she said, Dad, what's the answer to this? And I thought, Lord, I don't know. So, your daughter's taking the bar exam. You got to get her through the bar exam because you got to get her off the home payroll on somebody else. And so I go rushing down to the office where we use books. And started studying this, and after about an hour and a half, I decided, okay, and I just about dialed her number, and then I said, oh, Lord, I said, this is what I do at work. I was a circuit judge, and I was a judge for a long time, but I've got to get it right this time. So I had to hang the phone up, study for another hour and a half, and finally called her, and then I sweated that whole bar exam over the fact she had flunked because I'd given her the wrong answer, and this time I had to be exactly right. I mentioned that because the law school and the resources you have here, I think, give you something that you ought to make sure you take advantage of before you leave. One of the reasons I taught here is for a good number of years, I happen to have both Buena Vista and Lexington as part of what I did circuit riding. And I would come over here, and my secret weapon was Roger Groot, who taught criminal law. He also taught property and everything. He was pretty much acknowledged about the best professor, the toughest one, but the best one for about 30 years. My sister had him, both my kids had him, and all like that. And then he put it all in a book. Well, once Roger died, now his book's being written by Ron Bassicle. It's still good. Ron went here to law school, so even though he's been teaching at Richmond, his background is pretty good. But also, and you ought to get to the point where you know the books well enough. If you're in Virginia, and you have a Virginia judge that went to W&L, then you cite Roger Groot's book, and you cite the older version that's still got his name on the spine, because that's the gospel. And actually it would work for any judge, because he was the word around here. But I appreciate y'all letting me sit in and horn in on this class, because I'm in senior status now, which basically means I don't have a law clerk, which means I have to do my own research. Now, I have unlimited, and nobody holds the clock or the dollar on me for LexisNexis or Westlaw. I very seldom use them. Very seldom use them. And that might be a hint. One of the problems you're going to find, and this is what struck me when I first left here and went back to being Uncle Sam had jobs for all males over 18 when I was getting out. So I had to do the Army for a couple of years, but I went back home. And all of a sudden I found out, one, you have limited time that you can devote to something. Chris mentioned 10 minutes, but typical, you'll get a case that you might be able to charge $200 to a client, and they'll have a hard time paying that. But it's some uniform commercial code thing that you could spend 3 weeks researching, and you can't. You have limited time and you have limited resources. Before you leave here, close up your computers and go wander through this library. And you go down in the stacks where the different states are. If you're from Virginia, you're luckier because you're going to have a bigger collection there. But if you're from one of those, you go look through and find out what are the good books. And so you will then have an idea, and do this if if you're going to be clerking in Massachusetts. Go find out a little bit about it before you go up there this summer, because you'll end up with like what Chris says. If you've got a criminal law question, you're going to go to group. Another one where you might go is you might go to the book on jury instructions. Now, if you know the background, most of the jury instructions were actually written by Roger Groot, because he was on the panel and he knew more than anybody else that was on the group that edited them, because they give you the detail and it will get you into the point the quickest. So go look at what books are. Thumb through these am jurors, corpus jurors. You'll end up with a certain knowledge. You ought to have that before you leave. You'll never see a library like that again unless you happen to practice in a town with a big law school library, because nobody can afford them. You want to go do that, not off the computer, but in the books, because as was mentioned at some point, one of the beauties of the books is you can browse. And you'll find out quite often this statute isn't the one you want, but the one 2 pages over. What happens in Virginia, I presume it happens to everybody else, what started out as one statute in one recodification, when they just redid the book, they broke it into 3 pieces. And you won't get this off the computer. If you don't put those 3 pieces back together, you don't get the whole picture. But there's a lot of browsing, and I think, and this is, I can use a computer. I'm good at it. I can probably. I've always been a better researcher than anybody that ever worked for me. And I wouldn't hire somebody if I wasn't going to be better. I'd come back here and talk and do it better. I have to be better. So I like computers, but they cause a problem. One, I think, is what I call a tunnel vision or myopic research. You get a small view. And actually, Sally Wine, who was a law librarian here for years, finally capsulized where the trap is, I think. If you're going to do computer research, you have to know the words that will always be connected with the concept you're doing research on in order to get the hits you want. And if you think about that, that's way down in the analysis process before you're really going to know the words that you always will deal with when you're doing research. So watch it. And then the other one you need to do is, as a practical matter, and this was one of the toughest changes, besides the fact that we didn't have many books. Luckily, I was close enough to W&L, I could come up to this library and I wanted to. You had limited, and you have limited amount of money you can put on it. One, the client can't afford you to do a law review research project on this. Or you can't afford the charges that come from whatever subscription you have. As I said, I don't have to pay for it now. You mentioned, for a few years ago, Commonwealth attorneys didn't get research. They used to come up and we had some ways they could use something else, which we did for both sides, but now it's a little bit more available. So you do have that limited resource. And the other real shocker is when I went to law school and when I left here, I always went and looked for the case law. That's exactly opposite from what you have to do when you do practical law. And when you got a summer job, you're going to have practical law. You start in the statute. And you got to know the difference between annotated and unannotated, because you don't want to reinvent the wheel. Use the annotated code because somebody's done all the research and says these are the most important cases you've got. I had this question come up yesterday. it was real work. There was a petition for rehearing. We'd already thrown the case out. And they had filed a petition for rehearing, and it had to do whether they had stayed the previous order, because if you don't stay the final order in Virginia after 21 days, it's too late to start another process. And the other two judges were older than I am and been around longer, and they said, well, I think this was enough. They stayed execution of the sentence. And so what you do, in this case it was a rule, pull out the rule book, third annotation had decided it. Exactly opposite from what they thought. Third annotation down. There it was. Now, getting that annotation, I went and read the case and then read a citation to it. And so I got on my research. I did that research in about 12 minutes. If we started with the cases, it would have taken about 3 days to find. Now, the problem is, like this is the example you have. In Virginia, the code book is has annotations to it, but Westlaw doesn't have that. In one at Mickey, I think it was Mickey's. Well, maybe one of them does not have it because it's a work product of that publishing company before they got all bought up by Lexus and stuff like that. But that's the place you start. And frankly, if you've got access to the books, go to the book because you can flip around and you wander. That's why I go look at what stacks have for the different treatises in the areas you want. It might not be Groot's book on criminal law, but right next to it is the book on criminal procedure. And it's actually more of a procedure problem than a substantive problem. And you kind of get to know the resources that way, and find out as much of that as you can. The only other thing I got to mention is find some way of capturing so you can reuse any research you do. And now it's much easier now with indexes where you can just use a computer and just search anything, even if you just throw it in to a Word document or something like that. But come up with your own index, because if you've studied this point, eventually it might come back. And at least you know, well, in this year, in 2013, this was the most important case, and you don't have to reinvent the wheel. And all of a sudden, you'll be able to come back and answer questions in 10 minutes that otherwise from raw would take you for a long time, because you do have limited resources, and you got to be practical. And your law firms will love it. When you get to wherever you might be working, go to the library. It may just be the back room. It may have cobwebs in it, and see what books are in there. One of the best digests you can use is the Horn books. When you come to law school, everybody puts down the Horn book and all like that. I found out they were probably pretty valuable because my first year we had to go down to Norfolk for a funeral, and the federal judge was a good old friend of my father's. We'd gone to W&L together. And he took me down to introduce me to the judge and all like that. And I happened to notice, because I'm now a law student, I can recognize it. This time they were all green binders. Horn books. And behind the federal judge's desk, the closest books to reach for were about 4 Horn books. And finally I thought those were the ones you threw away when you left law school. But do that. When you're in the judge's office, you look and see which of the books closest to what that he can get without having to get out of his chair. I promise you it's going to be the code book. In Virginia, if he does any criminal work, the Groot's book's going to be there, and the Horn books. But go to your library that you're working for, and if they have the state code, and I promise you if you're in Virginia you're going to have at least one copy of the state code, then don't go on there and use that damn computer time, which is expensive, and at least runs against it, and you get a better product flipping it. Now when you want to do your paper, and you want to do cut and paste, then go to the computer, cut and paste, and you don't have any worry about miscopying and putting a knot in when it shouldn't have been in or something, or leaving it out. But anyway, you got great resources. They're here. So learn what's available, because then you'll know when it's worth making a trip up to a big library, or when it's really worth going on to the big world of computers. Your problem is that there's too damn much stuff out there, and you want to weed it down. So find out who's done all the research for you already, and if it's criminal law in Virginia, you've already heard from him what the answer book is.
I think the judge made several excellent points there. I might weigh in on just for a second. One is the ability to browse the section before, the section after. You can do that on Lexis and Westlaw, but it's not. You might not do it if it's not staring you there in the face. Whereas you pick up the actual code book, and Lexis must have bought the Virginia code because
yes, it was Mickey publication out of Charlottesville, and Thompson bought Mickey and all like that. And that's why Mickey's jurisprudence is only on the one. I can't remember the heritage of a lot of them, but that explains why one has it and one doesn't. Fine law doesn't have it.
Fine law, yeah, I don't use it because I don't think it's as good. But that's what Virginia lawyers get free through the State Bar website, I guess.
Yeah, it's cheaper than Westlaw too. That's why it got so popular. It's much cheaper subscription.
Fast case is another.
Well, that's what I'm
Resource, yeah.
saying. Fast case. But now the Lexis will have the annotations on the statute, but still it doesn't help doing what the judge said, to be able to look at the one before, look at the one after. It can really help you. And I totally agree with that point. And the other point that he made about don't find a way not to have to reinvent the wheel. I'll tell you how I do that, and I think that is critical advice to any young lawyer. I will go to Lexis when I find the case that I want, that makes the point that I want. I'll go to Lexis and download that case into a Word version, and then I'll save the Word version to my documents folder, and I have dozens and dozens of folders and subfolders. Like one subfolder might be search and seizure. And then if you click Save As, you can save the case as, Commonwealth versus Bumgardner, and then with the citation. But that doesn't really help me that much to just have the name of the person. I'll create my own name that will say, something like, Commonwealth versus Russell, auto search and consent, or Terry stop in Virginia, and then I'll have a folder that has Fourth Amendment law, Fifth Amendment law. That'll say just confessions, and then I'll have a list of cases that has one little blurb for each case on the document name, and that really does help me a lot, because he's right. If you have a practice area, the questions will come up again and again, and that happens to me every week. And I start looking through my hard drive, and I see, oh, I had that exact question 2 years ago, and I'll pull up that case, and that'll be a Word document, and I'll reread the case for a minute, but then I'll go back to the computer and pull it up again and look at the Shepard's tag and see if it's, if it's been overruled. Obviously is one thing I want to look at quickly, and so forth. So, very good point.
If I only have one thing to add in the context of a law firm, is we don't have the luxury of having unlimited Westlaw and Lexis access. And what our law firm does is save costs. Is we have a flat rate subscription, so that we can't go outside the parameters of that subscription unless we see a little dollar sign, which means you get into dangerous territory, because they're going to charge you extra for it. So one of the best resources for us in a law firm is, as the judge mentioned and Chris mentioned, is to start with existing resources in the law firm and work product in the law firm. Our law firm has a research and resources folder, and we organize it by our immigration issue, whether it's deportation proceedings, it's in a a visa for an employer. And in that folder, you get not only the specific cases or the annotated articles, law review articles, we actually see the date it was modified. So you know how current or not current the information you're working with is. The other thing I recommend is in the immigration practice, a lot of our cases can be very similar to what Chris sees in his criminal practice. As you see the same type of defense, deportation defense, and what we do is we work off kind of a knowledge and experience you gain over time, because you remember, oh, I remember this case with this client, Julio, from 2 years ago, that was the exact same case with similar facts, and we save our client files, and then you can look at the pleadings or the motions and work from that basis. But as Chris mentioned and the judge mentioned, always important to make sure that your research is current, to shepherdize it, check the citations, and then usually in a law firm we just build on that resource. We stand on the shoulders of giants, as Google would say, that way.
That made me think, because I want to re-emphasize something that was mentioned earlier, and that's using these books. They're generated from the continuing legal education panels and all that are put out by the Virginia Law Foundation. And all the various areas of law have these panels. These are some of the best resources. They're usually loose leaf, about an inch thick, and the annual criminal law one that will be out, and it's been going on for 30 years. These are some of the very best books in whatever field you're in, because, and this I think will hold true in most states, I know it's the case in Virginia, the lectures are put on by the best lawyers in the state. So you're getting the best minds. It's all distilled. Then they often put in a lot of the practical forms. These are the forms these guys use. It's the best, and they're all down there, and you never think to use them because it isn't in an expensive binder. And there's one book in Virginia they have it, and it's a project that was started by the young lawyers, particularly aimed at lawyers who had just been practicing for about 5 years. It was the Bridge the Gap Committee of the State Bar. Now, some years ago, they came out in 2 big binders, and they were called the Jolly Green Giant, and it was the secret answer to everything. Unfortunately, they changed the damn binders, now they're blue. But anyway, I still call it Jolly Green Giant. It is really, if you're brand new in an area, it's almost every substantive field broken down for the elementary things. So if somebody gives you a workers' comp case and you don't know anything about it, which is most people, you can go there, it'll kind of explain the background and lead it into you as a total rookie. And then in the back are some wonderful forms, but also the references to the more advanced ones when you get out. Those are the type things you'll find down in the stacks. But in Virginia, if there's an area, it's a great area, because what you're going to get when you go to work for somebody for the summer, they're going to give you something. And they might as well be speaking in Greek as far as your ability to understand what they're talking about. It's totally foreign. And of course, if y'all anything like me, you don't want to admit you're dumb. That's the other thing. That's another tip I got. The mark of an experienced lawyer is the one who's confident enough to tell you, I don't know the answer, I'm going to have to look it up. It's the mark of the experienced lawyer. When I was very first practicing, to me one of the really embarrassing things was you go to court and you sit in the wrong chair. That's terrible. Worse than that, you got a client and you sit in the wrong chair, and then he knows you don't know the first thing. So you got to go to court. It's court appointed, of course. The fact of the matter, if you've been court appointed, your client has been to court longer than anybody in the courtroom, including the judge. But you go in, and I decided this way you answered this particular dilemma is you kind of acted like you were busy talking to your client out at the edge of the door and waited until the other guy went in and sat down, and you took the chair that was left. And then I was actually holding court over here, and one of the most experienced trial lawyers in the state happened to be up in Lexington that day. And he came up, and here I'm the judge, but he didn't practice. He's a contemporary of my father. And he walked up and he said, "Judge, in your courtroom, where does the defense counsel sit?" And then I realized the experienced people will ask the question. And the answer really was, it's different in every state. In every courtroom, who sits where. Over here, you could get in Lexington, in the old court, you could get in a fight if it was a personal injury case, and you, as a defense counsel, sat closer to the jury than the plaintiff's bar wanted to be, and the plaintiff's bar was a local attorney. I almost had a fight doing that. Ask the questions. It's not bad. But if you get dumped with one of these things that you really don't want to ask, what's workers' comp? You know, is that common law? Or something like that. Go to one of these books like The Jolly Green Giant, because everybody started off not knowing a thing about whatever the subject was. And those are some really good books to do it, and we'll get it into you real quickly. Find out what book is the answer book in your state for evidence law. There's hardly anything you're going to do in any field that doesn't involve evidence law. And also find out who's worth reading in procedure. And recognize this, there's a lot of books out there that aren't worth a darn. And you got to know which ones are worth bothering with, certainly which ones are worth buying if you can actually buy them. But there's a lot of junk out there, and one of the things that computers have made easy is printing junk into nice-looking books. And so you kind of have to, and ask one of the old guys. What are the books that count around here, and save a lot of work and get you going real good.
On a similar note, I worked as a summer associate at Bowman and Brook. It was a national trial firm specializing in products liability. And probably the most important thing I learned, which took me about 2 weeks, is asking the right questions too. When you first get a research assignment, you will likely have little to no idea what they're asking you to do. So what I would do, for those who are technologically inclined, if you have a tablet computer and can record your conversation with the senior attorney or the person you're receiving the assignment from, and then do 2 things. 1, write an email with your understanding of what the research assignment is. Get it in writing. And then send that email to the attorney who assigned you that topic, because what you do is you confirm the parameters of the research. So before you hit your resources and your secondary resources and Google, Wikipedia, fast case searches, you're able to get a good idea of what you're looking for based on the person who's giving you the ideas. And the second thing I would do is always ask, what's my deadline? When I was in the law firm, sometimes they say, oh, just a few days or a week. And then I say, okay, would you like it in 4 days? Or would you like it a week from today? Just to confirm that deadline. And then a little trick I would do is try to get it in earlier. If they asked it for it in 7 days, get it to them in 6. If they asked you to do a research assignment in 2 hours, try to get it to them in 1. And by doing that, you earn a good reputation, and it also just fosters a teamwork approach to legal research. This was what I've been doing in my experience with law firms, is that it's a team approach. You might be doing the research, but you're giving it back to a senior attorney who's going to incorporate it in a pleading or a motion or any other assignment. And so being sure of what you're being asked to do and then getting it in writing, confirming it with your senior attorney was certainly a big help for me in my experience.
Thank you. Those are great points. I appreciate each of your comments. We have about 10 minutes left. I'd like to open it up for questions for our panelists.
Great question. It would seem to me it would be much more practical if you were standing in a courtroom and you're put in a situation where you're kind of doubting a point of law or something like that, and maybe you want to refer to a book real quick that's sitting at your table. So that's something I'm kind of curious about. We're all stuck using computers all the time doing research and everything, but if you're in a courtroom and you need to flip to something really quick, I would assume you're not able to whip a laptop out, but maybe you are able to pull a book out. Am I right on that? Am I wrong on that? Is that common? Is it frowned upon?
I have one book I take to court, and it's a, I'm trying to think of the publisher, but I've been getting an annual update every year, and it's called Virginia Criminal and Traffic Law Manual, and it's a reprint. It's not annotated, but it's a reprint of Title 18.2, 19.2, which is criminal law, criminal procedure. It has the rules of court, it has the motor vehicle code, and it has the U.S. Constitution and a few things. And actually, The traffic court judge, the general district court judge that I have every week is Judge Gordon Saunders. He was Commonwealth's attorney in Lexington for a number of years, Lexington Rockridge, and hired me as an assistant. That was my start in prosecution. And he asks me probably once a week, what does the code say on that point? Do you have your book? And so I make sure I always have that book. It doesn't have much case law in it, but it's a soft back book, but pretty thick. But it's at least a start on some things. That's a good question. And there's probably not one book that could do everything for you that you could always bring. But certainly, I think most judges, I've never seen a judge, and I special prosecute cases up and down the valley a little bit. If there's a conflict, I've never seen a judge not allow a lawyer to refer to a book on counsel table. So I think that's a good question and a good idea to at least have something.
Yeah, I think that's a Mickey thing. It's just a compilation of specialized for that. You mentioned all that. Everybody's starting to show up with computers and flipping them over. Right now, the Supreme Court's going for a big thing about whether they're going to let you do it and how they're going to make you promise that you don't turn the cameras on and all this kind of stuff. The fact of the matter is, I don't think he got time to do it. Again, this is the mark of an experienced attorney. If you get called on a case and you don't know, don't bluff it. Say, I don't know that case. Just do it. Don't bluff it. That'll get you in real trouble. The one book I always took, was the evidence book. It started off, they got this thick. Now they've gone to the code, and it's back down to being that thin wire. In trial, the code, the evidence code, the most practical one, is probably like the only thing that you can take. If you go to court and there's more than 10% that comes up that you hadn't anticipated, you didn't prepare properly. But you mentioned the computer. I'll give you my example. When laptops first came out, and you could at least put a disk in them, so I could take for Virginia, all the reports and the code, and on the day when we didn't do anything with criminal law, that's pretty much everything I needed, in a small notebook. And I had it out on the bench. When the thing comes up, you don't have time to do that, because you got to be listening to what's going on, and you mentioned it. And what ended up happening, it worked out perfectly. The word got out that, because I had this little laptop, of course you have, the things open up there, and you can tell that the computer's open. I found it wasn't much use in the courtroom. It could be now for transcripts and stuff like that. But the word got out that if you cited the case to me, I punched it and had it right there. That you better be right if you cited the case when I was the judge. I never did that. But I had this reputation. And it improved argument wonderfully. More importantly, it improved whether the cases were prepared properly. Because you didn't come in there. But to me, it illustrates that once in a while you could, but the lead attorney, whoever's responsible for that witness, has got too much to concentrate on. And you've got to concentrate on everything about whether the guy licks his lips when he answers a question or something, or to whether your client is snarling, and this is the guy that did the bad act, and you want him to be the choir boy. You have to be watching the whole thing. You're on stage. The best assistant might be able to look something up. So the first one is, if it's a key thing and you don't know, admit you don't know, maybe ask for a short recess. When you do have a recess, come back with it and do it. I've watched people in oral argument, try to go back and do it. You can't pick it up. There's too much else going on. So try to do that 10% rule, and you're going to miss it. You're going to miss it. Just don't make a habit of it. And don't want to go in there unprepared. And try to anticipate and then, fill in the blanks. And also know, and some of the judges you sit up on the panel and you're up there. And now with tablets, they're even fancier now because they got a more expensive machine. half of them are doing what I think probably half of y'all are doing. You playing card game or something else like that. You know, Harvard was going to ban all notebooks in their law classes because they found that nobody's paying any attention to classes. And they didn't want you to surf at the web and you know, watching Down the Abbey or whatever you were watching at the time. It's a great resource, but don't think it's going to be able to bail you out. There are a couple books that you might take and you can flip over there and you know, in the evidence, and you get the search and seizure or something like that. And then you can always ask for a break.
If I could briefly add to that, I guess I'm the only advocate for tablet computers in the courtroom. I take mine for two reasons. One, it helps me prepare my case. I have an outline of my legal arguments, and then with a program called, like an application called Dropbox, I have the case law I cited, I have the sections I cited. The judge does mention a ruling of law. I can search for it and pull it up immediately. So that's the one reason is case preparation, is I have all my resources I'm relying on in my argument, so I'm ready to refer back to them if need be. It is tricky to use your time wisely in doing so, but if you are in a pinch and you're just on the cusp of the answer, it's helpful to have it there and already highlighted or somehow tabbed so you can refer to it quickly. The only time I've done legal research while in a courtroom proceeding is when opposing counsel mentioned a code section I wasn't familiar with. So that was probably in my 10% of not knowing what to anticipate, but I had also downloaded an app where I had the Virginia code offline. I think there's a danger of wanting to take your computer or tablet and thinking you'll have access to Wi-Fi when you don't. So if you kind of bring resources offline and have them handy, that can be helpful. But I was able to look up the code section while she's giving a lengthy argument and just get a better understanding of what she was talking about. And then I did couch it with, I'm unfamiliar with the issue, but my understanding based on quickly reading the code section is this. So just to put somewhat of an argument there. But the learning curve is steep, so that's why I do rely on my tablet computer and pulling my resources together when I go into court, so I can be as prepared as possible, because I am still learning a lot.
Those things are great, because you can put a stack of transcripts that you're probably not going to have any need to know about. Put it in the computer. But good point. Take the stuff so you can do it offline, because you very likely get in there and find out for some damn reason that you can't get access, whatever it is. It's just, you know. Or you also have to worry sometimes you can't take the thing in the courtroom. And so that's again preparation. You find the local rules. Does the judge allow you to do it? You go to a courthouse where one guy does and one guy doesn't, and you just have to know it. The way you find out, you make good friends with the clerk of court. And also make great friends with the judge's secretary. That's got to be your best friend. You find out what kind of flowers she likes, you find out when her birthday is, and you make sure yours get there before the opposition get there. I mean, that's the key. I mean, everything, the first thing that always happen, and this is true, I don't know lawyers will tell you this, but judge can actually tell it. You know, the first thing they do is walk in and say, Sherry, what kind of mood's he in? And she would tell him, and it would be wonderful. He's in a bad mood. All of a sudden, you got the 5-minute argument rather than the 20-minute argument. You know, that kind of stuff. But those are the things, and they can give you a lot of help. And most of the times, if you ask, everybody you're dealing with, whether it's the judge, the prosecutor, he's been in the boat that you're in, and there, but through the grace of God, to go I again, you know, and they can help you. Just don't go in there like you know everything, and you're the, you know, the brains of it. It's kind of, in the Army, one of the things that you had to learn early was, you were a lieutenant, you may outrank the sergeant, but don't think you knew more than he did, or don't tell him, Sergeant, I'm the boss, I'm saying it, because if you do that, he will do everything by the book and let you fall flat on your face without ever having broken any regulation. Those are the hands that really run it. You listen, and they can help you. The secretaries, those clerks, don't ever tell a clerk, I'm the lawyer, I went to law school, I know it, you take this file. Or she'll allow you to file a will that's not properly executed is invalid, and you'll find out in 15 years the will's invalid, and that kind of stuff. So ask questions. It's what everybody does. It's the mark of an experienced attorney that's been around the block. And experience can, you know, you can gain that in just a couple of days if you do. Ask, and people will be glad to help.
Final thoughts, Chris?
What the judge said.
That's a lesson right there. Well, let's give a hand to our panelists. Thank you.